I'm Jake Bruton with Aero Building, and today on the Build Show, we are at our Spring Valley Aero project. I have a special guest today that I'm going to introduce you to in a minute. But this is part of our Business 101 series. This is us trying to make sure that outside of this is how you nail things together, this is how you air seal things, we want to explain how we're operating our business, the ins and outs, the rights and wrongs, what we've done wrong in the past that you can learn from. As Mike Durden says, we're never going to make all the mistakes ourselves. We may as well learn from somebody else's mistake. So I think that's the reason that I asked Jose to join us today. We are sitting more than 6 feet apart, so we're able to ditch the masks as well. So I wanted to start with a story, and if you've followed us on Fine Home Buildings podcast or the Unbuild It podcast, or even some places here with Reisinger before, you've probably heard me tell this story. That in 2015, I had a job that I lost $180,000 on. And that job was partially my fault and partially a very sly and coy, well-operating client, but it was avoidable. And it was completely avoidable had I done a better job worrying about my business and not just worrying about, is this house going to fall down or is it going to look like what they want it to look like? And the reason that it was my fault is because I had a very poorly written contract. The contract was not explicit. The contract left a lot of question marks. And I realized most of the way through the project what was going to happen, and that it was partially my fault and it was my contract's fault. And the moment that I realized, I actually think about this quite often, Jose, we were standing talking with the client, and the client said, but that's not the kind of shelf bracket we want. And I said, well, that's the kind I allowed for.
Yeah.
And they responded with, this is a really nice custom home, and that's not the quality we're going to be accepting.
Yeah.
And that shelf bracket wasn't noted in the plans, and it wasn't noted in any scope of work, because at that time I didn't create a scope of work. Mm-hmm. And I immediately knew, how do I fight that? I'm not doing anything dishonest. I'm trying to do my best. Mm-hmm. I'm trying to provide the best product, but how do I disagree with that? And then the extension of that was when it came time to start talking about cost overruns, there were all these things that we discussed that I said, well, we talked about that.
Yeah.
You know, we had agreed upon this. And I heard, show me the change orders. Show me where I signed off on that change order. Mm-hmm. And I immediately knew that my process had to change completely. And it actually was terrifying that I lost a ton of money, and terrifying that I didn't know what was going to happen with my business from a financial standpoint, but I knew it was never going to happen again. I knew that I was going to resolve those issues right away. And actually, before we were even done on that project, I went to an attorney here in town and said, I need help.
Mm-hmm. That's great.
And it changed the way we did business. So, if you haven't figured it out already, this is Jose Caldera, and he is an attorney here in Columbia. And actually, we were just talking about he's going to be getting our stuff. He's new to a firm that we were familiar with, so Jose is going to be our contract attorney now. But I thought it was a good conversation for us to have, just a Business 101. So many people in this industry are just carpenters, mm-hmm. and not business people. Mm-hmm. What do I need to do? What do I need to know as a builder about contracts?
That's great.
Yeah. So introduce yourself and then lead us into the topic.
Definitely. You raise a lot of great questions and bring up some very interesting points that unfortunately I've seen a lot of over my 10 years of practice. So my name is Jose Caldera. I'm a partner at Harper Evans Wade Neitemeyer. One of the major things that we do and that I have done for years is prepare contracts. So I'm all too familiar with all these pitfalls and all the things that you can protect against. So to the point that the question you just asked, some of the basic things that I would focus on, and just to keep it at a very 10,000 foot view, is remember that contracts are your friend. You should be using them, and you should be using them often for all sorts of types of work, okay? Whether it's relationships with a client, whether it's relationships with subcontractors, or any kind of distributors, or any kind of relationship you have that involves finances, it should be in writing. That's number one. Number two, I would add that anything you have in writing should be very clear and specific about what's going on. The number one area of contention when it comes to contracts is a disagreement on what each party meant. If a contract is clear and specific, then you avoid all of that. Because think of a contract as a document that records what we are talking about today for some future audience that is not involved in this agreement, right? You want that contract written in a way that there's no ambiguity or trying to figure out what did Jake mean, what did Jose mean. You want some third party to be able to read the letters on the four corners and know exactly what everybody meant. So you need that level of specificity, which means avoid any fancy terminology. Even if it's legalese, if there's some industry term, try to weed that stuff out. You want it to be as plain English as humanly possible. So that way a judge or a jury down the road can't be confused by what you were trying to say.
So I think there's a really good point there that number one and number two, those two things go together for a very simple, we're protecting all parties.
Yep.
We're protecting us and the clients should know that, and they should feel protected with the contract. And when you say, referencing it for a judge or litigation, that's what they should think too. Like, if we have to sue this contractor, are we going to get what we asked for? And you should think, if I have to walk off this job or if I have to sue these clients, am I going to be able to get what we've agreed to?
Correct. And it's a good way to specify, because hopefully a vast majority of the time, you won't ever get into that situation, right? But the clearer you are and the more you're preparing for that worst case scenario, the better understanding the client has of what you are going to do. And you can avoid this bracket situation because if you had an attachment on there showing all the items that you're going to be buying, if they come saying, well, that's not the bracket we wanted, you can open up to that page and say, this is what you agreed to. And everybody's just on the same page. And it makes the working relationship move ever more smoothly.
And so that's probably not in my contract. It's an attachment, the same as my plans. It's part of my scope of work. I can attach the estimates from the suppliers. I can say, here's my lumberyard's takeoff list. Absolutely. And that lumberyard takeoff list did have shelf brackets on it.
Absolutely. As a general rule, if there's documents that you're going to get from wherever or that you're going to use on the project and you have those documents before the client has signed, you should attach those documents to the contract.
Even if you don't think they're worth it. Even if you don't think they show value, put it in there.
Put it in there. Correct. Now, what you want to do, though, because sometimes things change. You might have a change order coming down the road. If that is the case, your contract should specify, how do we make changes? What are the rules of the road? Or do they have to put it in writing? Do they have to give it to you within 30 days before they want the change? Specify how it is. You don't want it to be just a handshake agreement because then it's your word versus theirs.
Yep.
The contract is the neutral arbiter.
Okay, so now we have a contract, or we understand why we're going to have a contract. What's our next step from there?
Okay, so we know why we have a contract. In terms of the guts of the contract, this is a very simple thing that unfortunately I see way too often. Make sure you specify who is contracting under the contract, okay? There might be a situation where a family member decides to finance something on behalf of a relative. Well, you probably need to have both the person financing as well as the relative who you're doing the work for sign the contract. Because ultimately the people who sign the contract, one, have the authority to tell you what to do, but are the ones that will ultimately be held responsible if they mess something up. So if you accidentally omit somebody who should have been a party to the contract, for example, if you have a married couple, you'll probably want to get both individuals to sign that contract so that they're both legally bound by whatever it is. And again, it goes back to the basic point of everybody in that household should know what is it that we're going to be doing and under what terms. So that's one. Number two, another basic point, where is the work going to happen? What property are we talking about? Am I working indoors, outdoors? Am I remodeling a specific legal, is it a brand new construction? If that's the case, we probably need the legal description of that land. You don't want to just give vague descriptions of where you're going to be doing the work, which ties into the scope of work. You want to make sure your scope of work specifies what is it that I am doing for this person so that they fully understand I'm doing this and no more.
Yep. Okay. So that's when we go back to the first point of protecting both parties, you're going to say, I'm doing A, B, and C. And by saying A, B, and C, you're specifically noting you're not doing E, D, E, F, whatever it is. And then it's not a conversation about, well, we didn't realize that the bathroom renovation didn't also include new doors on this elevation of the house.
Correct. And your contract for A, B, C, and D can spell out, if you want us to do E, F, and so forth, this is the process. This is what we have to go through. And then you want that to be in writing, so that way everybody's fully aware that we are now deviating from or adding on to the original agreement. Basically, everything needs to just be in writing, spelled out to the lowest common denominator, so that future people understand fully what's going on in this way.
Okay. And then where do we go from there?
Okay. So now, as we get a little bit more advanced, I would say you as a contractor, carpenter, should always think about the relationship you have with the folks that work for you and how much responsibility you are taking on, as well as how much responsibility you're putting on the home owner or the client that you're working for. You always want to have some kind of insurance language in your contract that specifies what your insurance covers, like your limits, so that way the client is fully aware of what you are going to cover if something happens. Vice versa, you want to have something that's called a version of what's called an indemnification or hold harmless provision, which basically says, client, if something happens that is outside the scope of the work that I am doing, one of my contractors gets hurt because you were neglecting to maintain your property in some way, I'm not the one that's going to be held responsible. You are going to be the one that protects me in that case. That protects you and the client on both regards, because it notifies the client that, look, I'm taking responsibility for any mistakes that I make, but you are also responsible if something happens to my crew that is outside of the parameters of what I am taking responsibility for.
That makes sense. And so we've touched on it a little, but that hold harmless agreement, I immediately was like, oh yeah, we should talk about our subcontractor agreements. Mm-hmm. And we have the same thing with our subcontractors. And while our subcontractor agreement is multiple pages long, and they get most excited about the idea that it says we're going to pay within 21 days instead of 30 days because we want them to show up and answer the phone when we call. It also has that hold harmless language, and it has that insurance language. And we can think of that as basically the same thing that we're signing with our clients, right?
Absolutely.
It's just there to protect both of us. It's just there to make sure everybody knows what's happening.
Correct.
And while we have, you've heard me talk about it before, 12 people in this market that used to work for me that have business licenses, and those are people that I would let watch my kids, we still have subcontractor agreements with those subcontractors.
And that's the right way to go, because ultimately you're not just protecting your interests and their interests, but it goes back to the point of everybody knows what the rules of the game are. This working relationship, last thing you want to do is to have something go wrong and not have protections for each other. Because if you don't have those protections in place, then it's going to get messy. Then it's going to fray relationships and destroy stuff. If you keep it business, professional, with a contract, that individual, hopefully, that any kind of mistake or issue that happens, the relationship will survive that because we all knew the rules of the road whenever it happened.
That makes a lot of sense, and that works for the client.
It works for the client as well, exactly.
So what else are we missing here when it comes to contracts?
So it is currently raining here. Something that I think every contract needs to have, and hopefully most do at this point, you need to have an act of God provision in there. You need a force majeure provision that covers you if something outside of your control, an act of nature or a natural pandemic, slows work down. If you can't get materials for whatever reason because there's a shortage on the supply line, or there's a torrential downpour that is delaying work, you want to specify that you are not going to be held financially responsible for the delays that incurs. Or basically let the client know, and again, it goes back to everybody knowing the rules of the road. The client needs to know that in some situations, we might have to deviate from the terms of this agreement. And that's okay. That's perfectly okay. That protects you from a client coming in and saying, well, you're 3 months behind.
Yep.
Well, you know what? A national pandemic shut us down and I wasn't able to work. So you can't hold me financially responsible.
So I think that's a really good point, because when we talk about we're going to be sending you our contracts to update, and one of the things that I wrote down was, it says act of God, but we think it should probably also say COVID. We think it should probably also say there are health problems, there are things that we hadn't thought about until recently, that those would probably be covered already in the act of God category, or arguably covered. Mm-hmm. But now there is probably going to be a pandemic. it's gonna be in there all of a sudden.
Yeah, governors and presidents can issue states of emergency or national states of emergency for a variety of things. It doesn't have to be an actual natural disaster. It can be civil unrest. It can be a variety of different things. And you want to have the protections in place that allow you, if you have to stop work or slow work down, to cover all of those situations, even things that we can't anticipate right now. I didn't think that COVID would be a thing a year ago. Nobody did, right?
Yeah.
But here it is. We probably could have protected against that if we had a statement in there saying, act of God shall include any states of national emergency. All right, so
Taken care of. Yeah. And lined out so everybody can see it. If you see a theme here, that's everybody having the knowledge that they need.
Correct.
So if I'm a contractor and I'm currently operating without any sort of contract or a contract that I pulled up on Word, what do I need to do? What's the first step for me to work towards getting a contract that my company can run?
Definitely. So that's this is going to sound self-serving, but you definitely should consider talking to an attorney and having them draft some template documents. Not any one contract is going to fit every scenario. I mean, I'm sure there's folks who do just one type of job, and in those situations, maybe one type of contract will work. But by and large, you're going to have some variation and stuff. But since we all kind of do within a certain realm, certain projects, we kind of know in advance what kind of contracts we'll need. I would have an attorney draft a template document to use in those specific situations. Now, I understand that might be cost prohibitive. That might be something that people aren't really interested in. If that is the case, which I strongly recommend that you find a way to talk to an attorney first. There are a variety of legal services online, like LegalZoom and stuff like that have template contract documents. And there's some good resources on what specifically contractors and carpenters should have in their contracts available online. It'll require you to do a little bit of digging and copy and pasting, but that is a suitable option B if costs are a concern. But again, I cannot stress enough, there's nothing quite like having an attorney ensure that your documents, your template stuff is airtight, because we are the ones that are thinking, we are paid to think about the act of God scenarios, to how to word things to protect you from the unforeseen.
Yep.
That's our job.
I think the other big thing that Jose didn't hit on there is your choice of attorney needs to be based specifically on business and contract.
Yes.
Don't just go to the one attorney in your small town and assume they're going to know enough to cover everything.
Correct.
You won't have to go very far to find someone who does specialize in something. The legal system is vast, and you will find someone. And I would say, don't just call the contractor that you're friends with and say, who do you use? Call 4 or 5 people and ask who they use, and then ask if any of them have been sued and how well it went.
Yeah, exactly.
I know that seems like a silly thing to do, but that's the way you check on a contractor. Is you talk to references, you look at reviews online. There's no reason why we can't treat any service provider, including an attorney, the same way. We're going to try to have the best knowledge that we can.
Yeah. I actually, whenever I meet with potential clients, I always refer to how I operate. I say the way I operate is the way a carpenter operates. I bill you essentially the way a carpenter does. I am a specialist that focuses on a specific area thing, the law, and I am subject to criticism just like anybody else. And there's a variety of public ways to determine whether or not I'm a good enough attorney that you should hire. And you should do that. You should vet me. You should look at the Google reviews. You should check the bar website for the state. You should see if there's been any complaints against that person. And we aren't allowed to say that we are specialists under our ethical rules, but the reality is we all practice in specific things. For me, it's business and real estate.
Okay. Is there anything else that we're missing that you think is on the Business 101 Contract Basics, Episode 1 on contracts? I think we covered pretty much everything on your list.
Pretty much everything, yeah.
Okay.
I would say, one last thing I would say is when you are talking about the worst case scenario, if something unfortunate were to happen and you all were to, somebody were to breach the contract, make sure you spell out what happens in that situation. Okay?
Oh, yeah.
Yeah. Are we going to cap how much they can sue you for? You can lay all that stuff out on the front end, again, to establish the rules of the road.
So make sure the information's there.
Mm-hmm.
It boggles my mind how many people I even know in this industry that have gray hair and have been doing it for 40 years and would say, well, we've been doing it this way for 40 years, and they've never been sued, and they've never needed a contract, or as they thought they never needed a contract. I'm just going to make the argument that you should look yourself in the mirror and prepare to spend money and get a good contract and understand that this is what owning a business is, this is what operating a business is, this is what being successful in business is. And it's one of those things that I give a copy of our sample contract at the first meeting I have with clients. If I believe that you could be a client enough that I'm going to go to your house or your office, or you're going to come to our office and meet, I have a sample contract, and I have our sample scope of work, and I have a sample of, and I have a copy of our construction expectations. The more information you can provide that you're able to stand behind, the better your company's going to operate.
Absolutely.
Okay, Jose, I would normally shake your hand now. Thank you very much. I have a feeling you'll see Jose again. We'll go a little deeper on some Business 101 contract topics. Till next time, thank you for watching The Build Show. Don't forget to check out Brent Hull, Wade Paquin, Steve Basic, and Matt Reisinger, all on The Build Show, posting new videos every week. And until next week, follow me on Instagram, Jake Bruton. Thanks for watching.
Thank you. Thanks, Jake. Appreciate it.